Good morning, everybody. Welcome to WG University, which is Weber Gallagher's series of educational programs. This is our workers' compensation webinar series and a very special edition of it. Each month, we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage your risk in your business and for your insureds. My name is Paul Fires, and I'm presenting today with Stephen Pateco on my left and Chris Davis on my right, two partners from our Philadelphia office. Today's presentation is specially scheduled in light of a recent Supreme Court case, and it is entitled IRE Upheaval. Duffy allows IRE doctor to establish new injuries, something that's caused a great deal of concern and raised a lot of questions in the workers' compensation community. If you would like to view this webinar again or share it with others or see other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, please feel free to contact the firm with any questions at questions@wglaw.com. That's questions@wglaw.com. Okay, let's get started. The new Pennsylvania Supreme Court opinion, again, is Duffy, D-U-F-F-E-Y versus WCAB. It is a Supreme Court opinion, which means that the only recourse for the parties would be to go to the United States Supreme Court. And there's, of course, no guarantee that they would even take that case. I'm now going to turn it over to my partner, Chris Davis, who's going to give you the facts of the case.
Thanks, Paul.
Yes.
It's interesting. We expected to have a webinar on the Protz decision, but before Protz came along, all of a sudden we encountered the Duffy case. And as Paul said, it's a Supreme Court case, and it really kind of changes the game, so to speak, in the sense of IREs. So to talk about the facts really quickly, in Duffy, the claimant had injured both of his hands at work while picking up a live wire, burned his hands. The employer issued a notice of compensation payable accepting bilateral hands from an electrical burn. After paying the claimant 104 weeks of temporary total disability benefits, the employer requested the IRE. The IRE was held, and the claimant was assigned 6% whole body impairment under the sixth edition of the AMA guidelines. Claimant then filed a challenge within 60 days. He initially just challenged the whole concept of the IRE, but later amended the review petition to argue that the physician evaluator, the PE, failed to consider and note additional conditions that the claimant had, including adjustment disorder and chronic post-traumatic stress disorder. Litigation ensued. The employer presented evidence, medical evidence. The claimant testified. The claimant presented medical evidence. The workers' compensation judge found for the claimant. The workers' compensation judge determined that the claimant's medical evidence was more credible than the employer's medical evidence, and because the physician examiner testified that he never considered the adjustment disorder and the PSTD, he just considered the injury on the notice of compensation payable, that the IRE was invalid. The WCAB then reversed the workers' comp judge, and it went up to the Commonwealth Court. And the Commonwealth Court sided with the WCAB and determined that what was important was that the claimant's condition at the time of injury should be determined. It should be looked at from the IRE perspective and what is on the notice of compensation payable. So they determined that the IRE was in fact valid, which leads to the claimant appealing to the Supreme Court. And what happened next, Steve?
The holding of the Supreme Court is that the IRE was invalidated because the physician examiner failed to consider all of the impairments arguably related to the work injury. This is now a situation where the other conditions, the psychological conditions, had not yet been determined to be part of the work injury. Nonetheless, the court determined that because the physician examiner failed to or ignored a range of potential conditions that might be related to the work injury, that was sufficient to invalidate this impairment rating evaluation. The court, in rendering this holding, found that there was a clear duty for the physician examiner to not only determine what the accepted injury impairment was, but any other condition that's raised that might be related to the work injury. So all impairments that are potentially related to the work injury must at least be examined. And as the court went on to try to explain this duty, it was clear that the physician examiner must consider conditions beyond those recognized by the notice of compensation payable or a prior judge decision. So the court, in explaining this, said that this physician examiner now must consider causal relationship. But first, the steps are to identify all impairments, to examine the claimant and determine what conditions exist, establish whether those impairments are causally related to the work injury, and then move on to rate those impairments. So this is the first time impairment rating evaluators have to consider conditions that are not arguably presented as accepted work injuries. They must now do their own investigation through this impairment rating process. As the court went on to explain this, the physician evaluators have to not only look at potential diagnoses, potential pathologies, then rate the conditions, and arguably under the statute must consider the permanency of those conditions to determine whether the employee's at maximum medical improvement, which is necessary to allow the IRE to proceed. So this is basically the holding of the Supreme Court, and we'll move on now to the questions that are raised by this holding. A host of questions are raised, and I think Chris is going to address the first one.
Absolutely.
Right.
And just to be clear, the community has been abuzz about this for the last 7 to 10 days. We're going to do our very best to give you answers to these important questions, guidelines for how to proceed, and recommendations for what you need to do to continue to control exposure using the IRE as a tool. So Chris, let's take a look at the first question. Does the IRE physician now have an obligation to consider unaccepted medical conditions in addition to what is defined by the notice of compensation payable or even a prior workers' compensation judge decision when issuing an impairment rating evaluation?
Thanks, Paul. These are really important open questions, and we're going to go through it. And I want to kind of frame my answer in a way that's going to give you certainty from a defense perspective. Certainly, claimants' attorneys might have a different opinion, but I think what's valuable to this audience is to view it from a lens of what we think as defense attorneys. So, as of right now, I do feel that the IRE physician has an obligation to consider these unaccepted medical conditions in addition to what's defined by the NCP or even a prior judge's decision under Duffy. It's really a game changer where, what Steve mentioned is that now these physician examiners are almost becoming mini workers' compensation judges in that they have a duty to look at a claimant and say what impairment is related to the work injury or not related to the work injury. Even unaccepted medical conditions like the claimant in Duffy had, which was adjustment disorder and post-traumatic stress disorder. The Supreme Court looked at the AMA guidelines and specifically the 6th edition of the AMA guidelines and the language in the AMA guidelines, the 6th edition, to really flesh out that the duty of the IRE physician now is to consider all of these unaccepted medical conditions and to determine whether they're caused by the work injury or whether they're even an apportionment or a factor in the work injury for making a complete and valid IRE determination.
And you feel, Chris, that's head to toe up to and including psych?
Head to toe up into including psych. Now, what's interesting is, one of the things that's going to come up is that how far is the obligation going to extend? And I think that when you look at the overall picture of this, it's going to lead to some uncertainty because when claimants appeal this, a valid IRE, and it goes in front of a judge then is going to be required to look at what the physician examiner did to determine whether the physician examiner met their obligation to consider these unaccepted medical conditions.
Well, this poses a whole lot of additional questions, and let's move on to the next one for Steve. Did the Supreme Court give the claimant, the injured worker, the unchecked power through the IRE process to add to the scope of accepted injuries? Steve.
Thanks, Paul. In my opinion, no. The court did not give unchecked power to the claimants. They do have the power to raise new issues during the course of the IRE. They can complain of conditions not previously addressed, but they do not have an unchecked power to add to the compensable injury list. There still must be a determination. At this stage, in this setting, it has to be determined by the physician examiner whether the condition exists, whether there is a causal relationship, and then rate the impairment. The real question that this leads to is, if the physician examiner determines there is a new condition not previously recognized that is causally related, what effect does that have on the rest of the comp claim? And that's a condition that will be addressed as we move through the series of questions. In my opinion, claimant still has the obligation or the burden of proof to demonstrate there's a causal relationship of these conditions to the work injury for purposes of the rest of the compensation case. Within the context of the impairment rating evaluation, the examiner can consider these other conditions if he determines or she determines it's causally related. But we think there's a limitation on the concept of adding new injuries to the notice of compensation payable or previous judge determination for the rest of the case.
And Steve, on the dark side of your point, we may be having an IRE performed by someone in a specific area of specialty, then asked to comment about causal relationship in an area outside of his or her specialty. Isn't that right?
Yes, that is. And the Supreme Court actually addressed that situation and said if the physician examiner is not competent to address a particular issue based on the limitation of his expertise, he has a duty to have that assessed by another examiner. So your IRE physician may actually be referring the case out for review of a condition that he does not feel is within his expertise. So these IREs may become more complicated as these physician examiners try to fulfill their duty to address all conditions raised.
I think one of the interesting issues is going to be how does the Supreme Court's decision affect previous case law in the area? So, for example, Commonwealth Court in the Harrison case, it's Harrison versus WCAB, Auto Truck Transport from 2013, ruled that an impairment rating that includes conditions other than the accepted work-related injuries does not constitute an amendment to the description of the work injury. So what we're seeing is the Supreme Court saying one thing, but previous Commonwealth Court decisions saying a different thing. And the question is going to be whether or not Duffy is limited to the world of just an IRE, or whether Duffy can escape that world and go into the regular accepted injuries that you might see in an amendment to an NCP or what a judge does.
On that point, Chris, because Harrison has not been overruled, we will certainly be arguing it, and we will argue that Duffy did not address that particular situation.
Let's move on then to the next question. After Duffy, does the IRE physician have an affirmative obligation or duty to probe for non-accepted injuries? Now, before we answered the question, should they be required to consider non-accepted injuries? Now, do they have an obligation to probe for non-accepted injuries? That's a much closer question because the decision itself does not affirmatively require the IRE doctor to probe, but it does require to come up with a very well-reasoned and considered opinion as to the entire scope of injury. I think that with that instruction, the average IRE physician will in fact probe. Let's take a basic example, low back pain. It's reasonable to assume that a doctor might say, do you have radicular pain going down your leg? Do you have numbness into your foot? That might be a follow-up from this case. But then let's take it a step further. Low back pain. How are you feeling mentally? Are you starting to have mental complications from this? And many people who might be susceptible to a question like that could very well answer yes. changing the whole shape of the case. However, I do not yet believe that this case absolutely requires the probing for this, but as a practical matter, I think many physicians, especially when perhaps prompted a little bit by well-advised injured workers, will go down this path. What do you gentlemen think?
Just to review, Paul, if the employee who's being examined says, I have condition XYZ, the physician examiner must look at that. Right. You're addressing the situation where the condition isn't even mentioned by the employee. Must the examiner go further and try to determine if there's an impairment flowing from the injury that has to be addressed?
Right. I think the question is what happens to in a situation where a claimant comes in and is silent about other conditions? Is there an affirmative obligation to probe either by questioning by the PE or review of the records to investigate other non-accepted injuries or impairments? I think that's going to be the criteria that they're going to look at. I agree with Paul. I think if it's a natural flowing from like a low back to a radicular complaint, that's one thing. But to have a silent claimant not raise anything and then have an IRE physician probe and question the claimant about, impairments going back to mental problems that he or she might have had before the injury even, I think is not necessary under the Duffy decision.
I'd like to mention one other thing. You touched on it, Chris. Apportionment was a concept addressed by the Supreme Court as part of the evaluator's duty. This is not explained at all in the decision, and I'm trying to think of an example of where apportionment may come into play. Say an injured worker has a back injury, is clearly depressed during the evaluation. Is the physician examiner to then determine whether there was pre-existing depression made worse? If so, how much? And how does that factor into the impairment rating evaluation? Are you only evaluating the impairment percentage that was made worse? These are all concepts not fleshed out very well by the judge's decision, by the Supreme Court decision. They were certainly raised and again lead to questions to be answered as time goes on. But there are certain things that we will recommend that an employer can do in order to try to manage the situation.
So let's take this analysis step further. After Duffy, does the employer now have an obligation to pay for medical bills associated with conditions the IRE physician finds to be work-related, but for impairment rating purposes? Steve, what do you think about that?
I thought that was your question. My answer as an advocate for employers would be no. We think, at least I think, Duffy is confined to the impairment rating evaluation process. In other words, the physician evaluator may consider non-accepted conditions for purposes of rendering a valid IRE evaluation, IRE determination, but that doesn't carry over to the rest of the comp cases. Chris referred to the Harrison case. There seems to be a limitation on the use of impairment rating physician opinions in the context of the greater workers' compensation case. So to me, that means because a condition was considered by the evaluator does not mean it's now part of the NCP, part of the accepted list of compensable conditions for which compensation must be paid, including medical expenses.
And I agree with Steve. I think that Duffy is going to, we would argue that Duffy is going to be sort of that bubble case where you're not going to break through the bubble and have the employer be obligated to pay for medical bills associated with conditions or impairments that the IRE physicians finds to be work-related. Now, with that said, what we anticipate is that once the IRE doctor makes that determination that something is work-related, you might find the savvy claimant's attorney filing a formal petition to review to add those injuries. Under that case, that's going to be still his burden or her burden under the Workers' Comp Act to prove causality. The interesting question that Duffy poses is, Now, does the employer have sort of an obligation or a duty to disprove a negative, based on the physician examiner? Is the employer now going to go out and get their own IME and basically have the physician examiner be a hostile witness against its own IME doctor? I think that could raise a lot of issues in a can of worms going forward.
I agree with both of you gentlemen, and let me just state that we will be advising our clients to not pay for any medical bills that were potentially added to the case by virtue of the IRE decision, adding conditions for impairment rating evaluation purposes only. We are going to take the position that the NCP continues to control, or that a prior judge's decision continues to control. As Chris points out, it is very likely you'll see some review petitions come out of this, but they should be fought. There'll be a range of judges' opinions across the state because there's a range of judges with different points of view, and we see this being revisited again by the higher courts.
If I may, I'd like to just mention the challenges we're going to see. There's two types of challenges to IREs. Within the 60-day appeal period or contest period, where you're actually attacking the impairment rating evaluation for deficiencies, and those beyond the 60-day period where the employee would have to prove an impairment greater than 50%. This decision seems to be limited to the 60-day challenge period. If you get beyond that period, the employee is going to have the same burden as before, which is to try to prove an impairment of greater than 50%. And if in doing that, they bring in other conditions, they have to prove the causal relationship. So I just want to make that distinction. This is basically limited to the 60-day challenge period.
Right.
But we can expect to see a lot of challenges during those periods.
Let's continue to discuss the scope of claims management issue. Post Duffy, is the IRE binding on the future scope of claims management, for example, affecting how you evaluate work restrictions, vocational assessments, labor market surveys, job searches, and a follow-up IME? What do you think, Steve?
Same answer as on the medical bill question. I don't believe the addition of a new condition by an IRE physician affects the greater workers' compensation claim. There will be challenges by the employees, but our position is going to be to dig in our heels at this point and argue that the impairment rating evaluation was limited to that process and does not affect the rest of the case. Otherwise, you would have conditions added to the list of compensable injuries not established by an adversarial proceeding, not established through a due process proceeding where both sides have a chance for input, for discovery, for records, for various witnesses to testify. You'd be relying solely upon the limited investigation that could be performed by an evaluating physician in the context of an IRE. We just don't think that can be the case when you're going to influence the rest of the workers' compensation case. So the answer is very much the same. You don't pay medical bills because of a new condition until it's established officially as a compensable injury. Same thing, you don't consider work restrictions for a new condition. You don't consider these other new conditions unless they're established formally through a review process, other than the IRA.
Let's talk about employer rights and those rights that are also held by carriers and third-party administrators. Has the Supreme Court basically stripped employers of their statutory right to define the scope of injury? There's two parts to the answer to that question. For impairment rating evaluation purposes, I think the answer is yes. However, for injury purposes and for the purposes of managing the claim, we still insist that the answer is no. We want you to continue to handle the case based on the injuries that you accept. We want you to continue to handle the case based on the injuries decided by the judge and fight these issues consistently until this wrong is righted, hopefully by a future decision by the court or by legislative action. What's your thought on that, Chris?
I would agree. I think that it's more important now than ever for employers to take a stand and really hold on to what the Act calls for, which is the claimants to have the burden to show that the notice of compensation payable was wrong in some way. And take it, like Steve said, in front of a workers' compensation judge where you have due process and you have an adversarial proceeding and you have discovery. Instead of placing all of this responsibility on a physician examiner who is not an attorney, who has a limited understanding of medical records that might not be complete, as well as information that's supplied by the claimant at the time of the exam, which might not be subject to verification through cross-examination. So I think the employers need to really dig in their heels and post Duffy hold on to their statutory rights to define the scope of injury.
Let me also add that your claims professionals are the ones best suited and best trained to make these compensability decisions. And to Chris's point, when there's something that's done that is subject to challenge, that challenge requires due process and the intervention of a workers' compensation judge. An IRE physician is not trained to do this. An IRE physician has no experience in claims or risk management. A potential additional IRE physician brought in, it is unknown what their experience will be in this area as well, and we believe this process was statutorily relegated to claims professionals and workers' compensation judges only. So turning to our final question, what is next? After Duffy, where does an IRE fit within your exposure reduction toolbox? And let me also just ask the question somewhat rhetorically. You have to wonder why this wasn't simply thrown out because of PROTS, since this was done under the 6th edition guides. It would have made things a whole lot easier without causing these problems. But Chris, what do you recommend for clients going forward? Should they continue to use IREs, and how should they manage their cases?
So in my opinion, I think IREs still do fit within the exposure reduction of your toolbox. I think it's an important tool to manage those cases where the claimant is severely injured such that they're receiving benefits for 104 weeks. These are cases that are obviously severe cases, and you need to have that reduction possibility of limiting the case to 500 weeks. So I think it's very important that you still consider the IRE within your exposure reduction toolbox. But keep in mind that post-Duffy, I think it's going to be legally harder to win an IRE. Not impossible. It's going to be a bit more expensive, and it's going to be more time consuming. But again, because of the importance of capping these benefits at 500 weeks, it's my recommendation that you continue to use the IRE as a reduction tool.
Any thoughts, Steve?
Yes, we're going to hear from the Supreme Court again this year on PROTS. The Supreme Court in this decision, Duffy, actually indicated that there are deficiencies in the IRE process, and which should be addressed legislatively. So there's going to be further changes, but until then, IREs exist. IREs are one of the employer's major tools. My thought on this is it can be done, but it has to be managed much more carefully to make sure the IRE evaluation is valid and effective. You have to be very careful in what you ask the IRE physician to address, how you instruct the IRE physician, what information he's given about the compensable injuries, potential conditions that you know of that might or might not be related. He has to investigate those, and what to do if an employee raises a new condition heretofore not thought of. All these things have to be managed very, very carefully if you want to get a valid IRE that's going to be useful for you.
And let us leave you with this thought. The Supreme Court decision practically invited the legislature to readdress these issues and clean up some legislative loopholes in the current IRE section of the statute. Even though it's been in place for 20 years, they see some problems with it. So I invite each of you to reach out to your government relations and legislative relations arms of your companies and ask that they give this some attention when they have their meetings with the legislatures in Harrisburg. So I want to thank you very much for attending our webinar, IRE Upheaval, Duffy Allows IRE Doctor to Establish New Injuries. If you have any questions about this presentation, please contact us at questions@wglaw.com.